Hi, I'm Evan Wright, a partner in the regulatory department at JMW Solicitors. So what's a private prosecution? Well, it is a prosecution started by a private individual or an entity who's not acting on behalf of the police or any other prosecuting authority or body that normally conducts prosecutions. It's permitted by Section 6.1 of the Prosecution of Offences Act 1985. So why would someone want to take out a private prosecution? Well, the following are typical examples. A company trying to recover the proceeds of a theft or a fraud by an employee or a director as an alternative or in addition to civil litigation. Many companies prefer private prosecutions because they have a lower profile, and that's particularly important for people like brand holders who have a reputation to protect. Or a defendant who's been found guilty or not guilty of a criminal offence and might want to consider the merits of prosecuting someone who has attempted to pervert the course of justice or has committed perjury in the original case. Or maybe someone who might want to privately prosecute where the police either haven't the resources or haven't investigated thoroughly despite what are believed to be good prospects of success. Now, the rise in number of private prosecutions is partly attributed to decreasing budgets for public prosecutions. Individuals can join together to pursue a group prosecution, and a good example is a situation where, for example, a rogue trader or a company steals money from a string of customers and they want to recover their money and reflect that wrongdoing in a criminal conviction. And that group approach can also have very significant cost advantages. So can a public prosecutor stop a private prosecution? Well, yeah, because if it's being pursued in bad faith or it's clearly vexatious, a public prosecutor can take over and stop a private prosecution. In some circumstances, a public prosecutor might take over and finish and run the remainder of the case. So how are private prosecutions funded? Well, many companies will privately fund a case because it is cost effective to do so when compared to the cost and delay in civil litigation or the amount they are trying to recover. Individuals usually have to fund on the same basis, but many cases simply don't involve the recovery of money. So crowdfunding can provide a vital role to people who simply can't fund a private prosecution by themselves. And that can help in several ways. Providing the initial funding to complete or undertake an investigation so that a public prosecutor will then take the case on from that point. Initial crowdfunding leading to a decision that we can run a prosecution on a deferred fee arrangement. Now, that's a funding arrangement which we agreed to delay a client's payment of some or all of the fees until the end of the case. Not all cases can be funded in that way, and that arrangement is not without risk, but it's an option. Crowdfunding might be sufficient for the whole case, whether it finishes relatively early with a guilty plea or after trial. Can prosecution costs be recovered at the end of the case, and can I be compensated? Well, several scenarios arise here. Firstly, assuming they have the ability to pay and they're found guilty, a defendant can be ordered to make a contribution towards the prosecution costs. The main route to the recovery of prosecution costs is a claim directly to the court from what's referred to as central funds. And this can apply whether the defendant is found guilty or not guilty. However, the court can refuse to order payment of some or all of a private prosecutor costs. Particularly where a defendant has been found not guilty and the court determines that the prosecution just wasn't well founded. It's therefore very important to review regularly the merits and objective of the prosecution to avoid negative cost consequences. Now, it's worth mentioning that confiscation proceedings can arise in cases where the defendant has obtained a financial criminal benefit and subject to meeting that statutory criteria and assuming the existence of recoverable property, assets may be recovered from a convicted defendant to address the private prosecutor's loss. So do I need to be legally represented when I privately prosecute? Well, no, but compliance with the criminal procedure rules and various rules of evidence are not straightforward, and disclosure obligations are tricky, even for a public prosecutor. So unrepresented private prosecutors can become unstuck even in the most straightforward cases, especially where the defendant's represented by a specialist defence team. So private prosecutors therefore usually engage a law firm to run the case on their behalf. The firm shouldn't only have a facility to privately prosecute, but should really always be able to litigate in the civil courts and provide advice from any number of departments with potential relevance to the case, and that might include commercial, insolvency, regulatory, family law, even clinical negligence advice. Now, JMW Solicitors have had a criminal and business crime department for nearly 40 years. The firm as a whole is over 500 staff based in London, Manchester and Liverpool. The department employs several former police officers as well as some very senior former crime prosecutors, and this is backed by one of the largest business crime and regulatory teams across the country. Now, all of this comes together to ensure that private prosecutors' chances of success are maximised on the most cost-effective basis. So in conclusion, prosecuting someone in criminal proceedings is a serious step, and a prospective private prosecutor really should seek expert legal advice before embarking on the exercise. It's not without risk, but a properly presented private prosecution can be a very effective way in which to recover losses and obtain justice, where public options or other forms of litigations are simply not available or preferable. I'm Evan Wright. Please feel free to get in touch if you want to explore the merits of a private prosecution. Thank you.